Hello viewers, welcome back to my channel. We were studying BSA, Bharatiya Saksha Adhiniyam 2023, and in our last class we had completed part 1, chapter 1 of the act, and today we will start a new chapter and a new part 2, chapter 2. The name of the part, the name of the chapter is Relevancy of Facts. Okay, so in the previous class also we had discussed loosely what is the meaning of relevancy of facts. Today also let us start in a layman's term. Let us understand what is the meaning of relevancy of fact. Okay, see, if there is a case between A and B, A is charging B for the theft of a jewelry, right? In that case, there A has the burden of proving the liability of B. Okay, A has to prove that B has actually stolen the jewelry and therefore he shall be punished. Now, in order to punish B, A has to show various evidences. Okay, A has to produce various evidences. And in order to prove evidences, first A has to show to the court how these evidences, if proved, will suggest the culpability of B. Okay, the court will put the question to A that you are trying to prove a fact uh, by giving evidence. Then in that case, how, if the fact is proof, if proved, will assist the court, will direct the court that B is liable. In that case, A has to show that this fact which he is trying to prove through evidence, this fact is actually relevant fact. Okay, relevant under chapter 2. Okay, okay, for an example, suppose A is or B is alleged to commit murder, okay, by stabbing through a knife. Okay, in that case, if knife is discovered in the crime scene with the fingerprints of B, is a relevant fact. So A may always show, A is the prosecutor here, okay, A may always show to the court that if this fact, that is the discovery of knife with the fingerprint of B, if proved, will suggest that B might actually was present in the crime scene, and he might have also hold that knife during the crime, and this suggests an inference that B might be the culprit. So this is relevant under, this fingerprint thing is relevant under section 4. Okay, so this was just an example to show you how the procedure works in the court. Okay, and what is the purpose of the relevancy of facts. Okay, now let us go through the language of the Bare Act. Here it is given, evidence may be given in any suit or proceeding. That means it applies in civil suits as well and criminal proceedings as well. Okay, of the existence or non-existence of every fact in issue and of such other facts as are herein declared to be relevant. So two kinds of evidences can be given: evidences of fact in issue and evidences of relevant fact. Fact in issue we have already studied, which decides the liability, punishability of the person, is a fact in issue. That is the direct question. Okay, or if you cannot prove the fact in issue directly, then you have to prove various relevant facts, which will make a chain of various evidences and facts, okay, which will ultimately suggest that A is or B is in our example is actually liable. Okay, let us move to the next section, that is section 4. Facts which, though not in issue, are so connected with a fact in issue or a relevant fact as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. Okay, see, the very first section of this chapter speaks about same transaction. Same transaction means if any crime is going on at that moment, whatever is happening at that moment of time. Okay, also whatever has happened little bit earlier of the crime, and what has happened just after the commission of the crime are all said to happen in the same transaction. Same transaction means in the same moment. Okay, in the same traction. Okay, that means there must be an active and linking connection between all these facts. Okay, this is called same transaction. Okay, so these all little facts will be a relevant fact. Okay, and evidences will be allowed for proving or disproving all these facts. Okay, and section 6 is also called res gestae. Res gestae. Okay, now let us move to the next section. Section 5. Facts which are the occasion, cause, or effect, immediate or otherwise, of relevant facts or fact in issue, or which constitute the state of things under which they happened, or which afforded an opportunity for their occurrence or transaction, are relevant. So, section 5 is actually offering various situation which is actually relevant. Okay, the first one is occasion. Okay, occasion means any situation, any circumstances which is actually helping in uh, in the occurrence of any crime. For example, if someone is alone in the house, okay, if someone is alone in the house and even the neighbors are not present at that night, so it is an occasion. This occasion is itself a fact. Okay, and this occasion is itself a relevant fact because this occasion shows the vulnerability of A, which is alone in the house, that any crime can happen against A. Okay, cause or effect. The second one is cause or effect. Cause or effect means if any effect which happens after the commission of the offense or any cause of the commission of the offense. Okay, for example, there is an old enmity between A and B can be the cause of murder of A by B. Okay, effect means the effect of the crime. For example, I've already shown you the fingerprint thing. Okay, fingerprint is the effect of the crime. Had the crime wouldn't have took place, there could not be any fingerprint. Okay, also the stains of if the stains of the blood is spread all over the dead body, these blood are also effect of the crime. Okay, so this proving these facts is also allowed because these are relevant facts. Okay, which constitute the state of things or under which they happened or which afforded an opportunity, this occasion thing. Okay, again let us go back to this example where A is alone in the house, even the neighbors are not present. This is affording an opportunity to the criminal to commit the crime. Okay, so this all will be relevant. So basically this occasion, cause and effect will be relevant. Now let us move to the next section, that is section 6. Section 6. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Okay. So it shows that motive or preparation for any fact in issue or relevant fact. Motive means the ultimate objective of committing a crime. For example, if B is a son of A, okay, and B committed the murder of A in order to get insurance amount. Insurance amount. In that case, it will be said that the motive of A killing B is money. Okay. So this insurance amount, or the fact that A had an insurance with him, is a relevant fact and can be proved in court. Also, preparation is also relevant. If B is committing the murder of A through poison, B might have uh, uh, B must have gone to the shop to buy the poison. Okay, B must have also diluted the poison into the milk or tea. Okay, so these all things are what? These all things are preparation. So these facts, the buying of poison by B, or and spreading of or diluting the poison into the milk of B, milk of A, is relevant. Okay. And if you go to the second part of section 6, it says the conduct of any party or of any agent to the party to any suit or proceeding in reference to such suit or proceeding, or in reference to any fact in issue therein, or relevant fact, and the conduct of any person, an offense against whom is the subject of any proceeding, is relevant. Okay. If such conduct influences is influenced by any fact in issue or relevant fact, and whether it was previous or subsequent thereto. Okay. So here it is given the conduct of any party or of any agent to any party to any suit or proceeding. That means the conduct of either prosecution or defense. Conduct means activities. Okay. Whatever activities prosecution is doing and whatever activities defendant is doing or the accused is doing, let us name him as accused A, like threatening the witnesses, okay, trying to hide the evidences. These all are activities which could be done by A. Okay. So here it is given the conduct of any party or of any agent to any party, the agent of A's conduct will also be relevant. Okay. In reference to such suit or proceeding, or reference to any fact in issue therein or relevant thereto, and the conduct of any person, an offense against whom, that is the victim, is subject of any relevant fact. Okay. Victim's conduct can also be relevant. Okay. For an example, if in a case of rape, if rape has been committed on any girl, and the girl goes on a trauma, okay, if she falls into depression, then in that case the depression is diagnosed by the medical expert. Her going into depression shows that something bad has happened to her. Okay. And the conduct of her which shows that she is in depression right now, those conducts are also relevant. Okay. Also here it is said that whether it was previous or subsequent thereto, the conducts of parties or victim may be previous, that is previous to the crime, or maybe subsequent to the crime. It doesn't matter. Okay. All these conducts will be relevant. Now let us have a look with the explanations. Okay. Now let us look the explanations. Okay. Explanation 1. The word conduct. Explanation 1 defines conduct. Okay. In this section does not include statements unless those statements accompany and explain acts other than statements. But this explanation is not to affect the relevancy of statements under any other section of this Adhiniyam. Here it is saying that the word conduct written here, okay, conduct of parties or victims does not include statements. Okay, only the conduct means the physical activities. Okay, whatever the physical activities the person is depicting will be relevant. However, conduct if relevant in any statement, sorry. However, if the statement is relevant in any other section of this Adhiniyam, in that case, the in that case the statement may be relevant here also, okay, but not generally. Now let us look at explanation 2. When the conduct of any person is relevant, any statement made to him in or in his presence and hearing which affects such conduct is relevant. Suppose theft has occurred in the house of A. Okay. Now A is shouting. Various people of his neighborhood stood around him. Okay. Now in that case, A suddenly shouts, "Police is coming." Okay. He shouts in a very loud manner. Suddenly, this person started running. Okay. After hearing the name of the police. Then in that case, the conduct of his running, okay, is relevant to show that this person might have actually committed the theft. That is explanation 2. When the conduct of any person is relevant, any statement made him or in his presence and hearing, police is coming, is a statement. Okay, any statement made to him or in his presence and hearing which affects such conduct is relevant. Such conduct means his running is a conduct, is relevant. Okay. Now let us keep ourselves limited to section 6 only today. Okay. In the next class, we will discuss the further sections. Okay, next sections. It is a very big topic, so it is not very much possible to finish it in a very short period of time or in a single class. Okay, but if you want to study very minutely, then in that case you will have to give time to various sections. Even the phrases of these sections are very relevant and very important for exam perspective. Okay, so keep working hard. Okay, I will just say keep working hard. Watch my videos again and again so that the concept could soak in your brain. Okay, goodbye, take care, and I will upload the next class very soon. Thank you.